Mr. Lords, yesterday Lords, Annexure 2, the order of appointment dated 1/12/2025, Lords, that is issued by the Government of India in the Ministry of Shipping, Transport and Waterways, Lords.
Without recording any reasons. The order goes. Single page.
Today's item number
116, Lords. 121. Yes, sir.
Who is for the other side?
Yes, I am there for the other side.
I am for the Paradip.
I am for the
What do you have to say about this interim order?
Yes, sir. One thing may I say, Lord. The metro were taken up on 4th, Lord.
There is one point which has struck me.
Yeah.
Is it proper to pass an interim order without recording reasons? You know the Shivakumar Chadda's case of the Supreme Court, 1993, Volume 3 SCC. Morgan Stanley, 1994, Volume 4 SCC. And then the subsequent decisions to follow. Can it be done with one line? Without recording reasons? Hey, 1993 and 1994, Volume 3 and Volume 4, take
Fine.
out. Mr. Sahu, you did not take that point.
Yes, that will not
Yes, yes.
copy.
We have the Lords.
Without reason?
Yes, Lords. It is there, Lords. I have a comparison, Lords. Yeah, I do not be right with it. So many judgments, Lords.
How can you support this order?
Yes.
On that score, you may have a good case, but is it not a duty of the court to record a prima facie finding in support of the interim order?
Also, it's prudence of the rule.
Because there is one division bench judgment of the Calcutta High Court which says that if the order is bereft of any reason, it is nothing but a nullity. It has gone to that extent.
Protected, also. So far as order is concerned, they said that we are joined. Document.
We are not, that is what I am talking about. You may, I just said, you may have a good prima facie
Right, Lord.
case,
Yes.
but still, is it not a duty? The Supreme Court has deprecated in a very strong words that one line interim order. In Shivakumar Chadda, the Supreme Court says that we are recording the wordings of Order 39, Rule 1 and 2 does not mean that there is a recording of the reasons. You just quoted the section and then pass the order. That is not there. That is not sufficient. You have to record an independent finding. At least 3 lines, 4 lines. But it can't. That is why I kept this matter today. That's the only reason which I thought. Have you got that judgment? Morgan Stanley or a Shivakumar Chadda? When a court passes an interim order, the court must record the reasons that why it is passing an interim order. 3 ingredients are very important. One is the existence of a prima facie case, balance of convenience and inconvenience, and irreparable loss and injury. These are the 3. I have point 4. Jurisdiction. The court must also satisfy that it has a jurisdiction. Otherwise, any order without jurisdiction is a nullity. 54 Supreme Court, Kiran Singh's case. What is this, sir? I think we have also passed an order, no? Probably on that. We have also passed an order.
Thinking of, we have not.
No, we have passed probably 1 or 2 matters we have. So how can I success?
But now I don't think that, but normally your practical court orders are being passed.
This is not a way. This is not a way to pass an order, interim order, unless you record the reasons. And these 2 judgments are very elaborate. Though they originate from a consumer forum, but still the court has says that you can't. Is the longest judgment why you are taking a printout?
Just may I, you are also pointing out the
Shift
1993, volume 3, SSC, page
161.
161. Look at the language which the Supreme Court has used. And this is followed in another judgment of Shivkumar Chadha.
Yes, ma'am.
Sorry, Morgan Stanley. Again followed. Look at the paragraph 2.2. The purpose of the temporary injunction is to maintain the status quo. The court grants such relief according to the legal principles ex debito justiti. Before any such order is passed, the court must be satisfied that a strong prima facie case has been made out by the plaintiff, including on the question of maintainability of the suit. That is what I say, the 4th principle. And the balance of convenience is in his favor and refusal would grant. The court would always willing to expand its hand to protect the citizen who is being wronged or is being deprived of a property without an authority of law or without following the procedure which are fundamental and vital in nature. But at the same time, the judicial proceedings cannot be used to protect or to postulate a wrong committed by a person who approaches the court. The power to grant an injunction is extraordinary power vested in the court to be exercised, taking into consideration the facts of the case. The court has to be more cautious when the said power is being exercised without notice or hearing the parties, who is also to be affected by an order to pass. In spite of a statutory requirement under Order 39 Rule 3, the courts have been passing order of injunction without issuance of notice or hearing of the parties against whom such order are operate without recording reasons for passing such orders. It is said that if the reasons for grant of injunctions are mentioned, a grievance can be made by the other side that the court has prejudged the issue involved in the suit. This is a misconception about the nature and scope of the interim orders. Any opinion expressed in connection with the interlocutory application has no bearing and shall not affect any party at this stage of trial. Apart from that, now in view of the proviso, there is no scope for any argument. When a statute itself requires the reasons to be recorded, the court cannot ignore the requirement by saying that if reasons are recorded, it may amount to expressing the opinion. Look at the strong words.
That is true, but only because maybe it is saying that you are also exercising jurisdiction under 226. So all these requirements.
We are exercising jurisdiction as an appellate court.
No, they are already single judge.
Yes.
That's
So that exonerate him from recording any reason.
Not that we should have not given some reason.
Absolutely. That is why I say 1 line, 2 lines, 3 lines,
Yeah.
sufficient.
Our High Court minutes in Tata Rabin case said, regarding this, without describing in detail the issues involved, it can briefly court can.
That is why I say 2, 3 lines. What I am saying is
Exactly,
that
2, 3
2,
lines.
3 lines, at least something. Can't be, sir. Can't be. We can't sustain.
Just now you said, balance of convenience or inconvenience ought to be considered as an important requirement, even if there is a serious question or prima facie case in support of the grant.
True.
That is Zenith case.
That is what I'm saying. There are many principles. Principles of balance of convenience, irreparable loss and injury. Even if a person has made out a prima facie case, that is not sufficient.
Sukhidam. Court says that all the ingredients, briefly at least, it should read out.
But that is not, I am seeing that this is very recurring feature. And why you senior peoples are not pointing out? No, sir, it does not absolve your onerous duty, sir. It is your responsibility.
Many things cannot be said.
Oh, I understand now.
So very one thing. The matter is not being listed today. Also, you can say that's not.
No, let it be. Let him reconsider. Let him consider the interim order. Let us record some reasons. There is no difficulty in this regard. But in this way, it should not be done.
Right, no,
Let's on the aspect of the Paradip Port, your lordships, he is working as a deputy senior.
I understand,
But
sir.
he is not occupying.
Sir, I understand on merit you can, but there should be some.
But he has got no authority. No,
Whatever, sir. That's why I'm saying he may have a very good case, prima facie,
Yes.
but there should be some finding. That is
The
what I'm
three ingredients has to be filled out.
The court authority is more anxious than the
That is what
present appellate.
that
Prima facie case.
Everybody talks about 3, but I always say 4.
Fine.
We don't see.
Mr. Nanda just now I read to you that this Zenith Metaplast versus State of Maharashtra, Honorable Supreme Court. That is
Here only no irreparable loss at all. He
No,
cannot.
whatever.
occupy this.
He was there in the
This case,
he never objected. He says caveat or I don't find any caveat. There is no walkout on behalf of the party reporters. He opposed that.
These are all on
But he never just raised this question. Now he is not.
Plus, I have raised this question, not only that, plus I have filed the application where he has joined.
Yes. So your lordship was wondering about the judgment of this lower court minutes. I was assisted and found that your lordship judgment is there in paragraph 4 in PS of.
Ananta Naik, Your Lordship, that's an order.
I never keep the name.
See, significance of providing the reason can be visualized from another angle, that if the said order is amenable to be challenged before the higher forum, it would percolate in the mind of the higher authority as to circumstances or reasons which laid the founding of the ultimate decision.
That is what is the important factor. How do we know that what played in the mind of a
Authored by my judge.
How?
Authored by your lordship.
we are conscious of the
Item number 2.
It is. Yes.
The NGT matter also due to intervention of NGT also. And as last time I had placed the judgment versus the Jairam Das versus State of Orissa. And we should directly to attend the inspection of whether the judgment is covered or not.
That's. Manage this, I only instructions say that, no sandwich has been extended in that area because of NGT order. There was various sandwiches which were, cut down and none of them have been granted extension. Regarding the judgment, if the Supreme Court judgment, it says that there cannot be any extension of this.
So what are you doing? Are you going to take a conscious decision for all? Because you have said that all the query we have not extended after the NGT proceeding is disposed of. So are you going to take any decision or what?
Same to the representation had been received to the managing officer. Made that representation to this point of. Because there is no provision under the leave deed nor under the.
That is what I think. But I have been noticing that in some of the matters you are extending the time.
It's not, yes, referred in, for example, it's referred in the reputation, few months were left for the completion of the lease period. Hence, that period was permitted to be,
Madam, similar situations are prevailing throughout this, right, since 2019-20 till today. Many cases we have seen by now that even after you execute or even after you find somebody successful and you grant him, but this remaining non-operational. So it is for whose fault? You want revenue, you have option, but it prejudices the other side. He invested money, so that money you are utilizing.
in the present case, the lease deed was over back in 2020 itself. It was back
That is
in
what.
2020.
So could he operate?
Only because the NGT order, it could not have.
So
that is
who's
what I'm
predicament?
saying. Whose predicament? Is he at fault or you are at fault? But there is an external force which really comes into play. Now, this is really, I do not know what terminology can be used. But one sentence I believe may be appropriate. That is a involuntary restrictions, which was not volunteers by both the lessee and the lessor, but there was some involuntary. Then in that event, these are the extraordinary and exceptional circumstances. You will not exonerate them from paying the annual the fees that you are collecting from them. But that is what is there, because I have seen in many of the cases, you are demanding for that period where neither you can permit him to operate nor they can operate, but both are stuck because of this.
Merely putting a clause in provision in the statute that it is their duty to get the clearance certificates after being declared successful, and you have his money and utilize.
Why don't you do one thing where before you put any mine or anything in auction, if the EC clearance is indispensable because of the common cause judgment of the Supreme Court, no difficulty, it is inevitable, necessary. Why don't you obtain the EC first and then float?
As per the rule 27, in some cases, EC is already obtained.
No, please, I am saying something else. EC clearance is important.
Putting the horse before the cart.
That EC will say that how much one can extract and how this is all the conditions are there. Before you float the tender, why don't the officer or the authority obtain the EC from there? And once the EC clearance has come, then put the thing in auction.
In many cases, the tenders also, you are finding them successful. Thereafter, you are not handing over.
2
the land-
years, the EC clearance, the EC
land
certificate
also.
is not issued, though they applied immediately. If this is the time which is consumed, what to do? There should be some, both have to be very reasonable in this sense. You take the EC. EC is already there. Put the thing in auction. Whoever is there on the basis of the EC, he has to work.
We have demonstrated
Here
more than 20 cases.
here
let's see.
subsequent to
Well, let's
that,
see.
this order has come and once everything was
Oh,
completed.
I understand. So now if there is any kind of a restrictions being imposed during the currency of the lease, then in that, they are not at fault. Neither you can say that you are at fault.
This judgment clearly refers to such a situation, my lord.
So what it says, that no, they will go on paying.
It's the extension is not possible. my lord. Only to that.
I understand, but in the extraordinary circumstances, I know there is no provision. Yes.
No, Lordship, just tell me.
Para 27 onwards. Here also the facts were the same, my lords. Here the operation of the lease was suspended due to NGT order.
What? Suspended?
The operation of the lease after the execution of lease was suspended due to NGT order. Here the court recognizes the fact even the leaseholders were not part of the NGT proceeding. Thereafter also they were the sufferers. But in those circumstances also the court did not grant extension
So
because
you don't charge them also. Pay back whatever they have paid. Pay back with interest. No difficulty. We will not extend. I know there is no provision. Then pay back.
so that instruction may I just get what
Instruction.
whether what was charged or whether advance payments are made. There's no agreement in the because till 2018 I think it was operative. For 1 year it was not able to operate.
2 years. 2 years. 2 years.
Yes, correct. 2 years.
2 years.
43, you are saying?
Yes, my lord, 43 is there, my lord.
Okay, pay off the entire one with interest.
Here, my lord, if I may just,
That was a policy decision. I do not know what is the policy decision taken here.
here, my lord, the state of UP had taken.
There are, I do not know, there were two distinctions, but in the latter portion, I do not find any distinction is sought to be made. The distinction was that there were some mining leases
Where the,
where those who come within the forest area, section 4 of the Forest Act prohibits somewhere outside the forest area. Question was section 20 notification under the Forest Act. The court has said that the NJT has passed an order that there was an injunction. Even our High Court of the Allahabad also passed an order. Ultimately, the GO was quashed. The court says that in absence of any specific provision, we cannot direct the extensions. But definitely, because since they were not at fault, neither they have done illegal mining, nor they have flouted any of the clauses or terms and conditions of the lease deed, then in that event, it is unreasonable on the part of the state to keep the security deposit or the advance royalty which they have already paid for the period in which they cannot do a mining operation, then it's to be refunded.
here,
And if it is to be refunded, you refund
here
the
state of
entire amount. Why they will report to your partner?
Here state of UP had consented to that proposal that.
No, sir, this was not a consent.
Yes, my lord, I do.
Please read it. It was not consent. Paragraph 43 is the specific order of the court. That's a finding. With a categorical finding.
That I have seen, my lord.
Please read. There are. This was a submission which was advanced. It was not a concession. You have to read after the path we take. That's heading.
Yes, my lord, from para 20, para 31 onwards, where they talk about the dilemma in the issue and then.
I'm just talking about the decision of the court under the heading path we take. The court accepted.
Here is my, at para 41, last line, if I may read, my lord.
Yes.
This is what forms the basis of the submission made on behalf of state of UP, that they are only liable for refund. This was the submission made.
That is not liable means this is not a concession in that regard. The inevitable conclusion that would arrive is that you cannot have a cake and eat it too in both the ways. Nor can have a bird in the hand and also the bird in a bush to be given to you. You have to choose either one alternative. If they were prevented from operating the mining activities for no fault on their part, nor even a fault on your part, nobody is a wrongdoer, but because of some interdict externally imposed, then in that event, why he should be penalized and you should gain. Please consider. You are gaining, he is losing. When neither he is at fault nor you are at fault.
That aspect, my lord, I do understand.
Pay back the entire royalty, pay back the entire security amount which he has deposited.
The reputation is not made and they just want extension. The prayer is specific for extension.
We can.
And my lord,
The one prayer is there as
Well, it's as per
to
that
pass,
44.
to pass such a further order or orders as your lordship may deem fit and proper.
The
I
entire.
think this language is there in the prayer. Is there?
Lordship, that is their lordship.
The entire reading is not to that balance and one more point, para
Sir,
44.
madam, kindly visualize.
Super-
The entire reading is for extension,
Yes, ma'am.
correct? If we feel that the extension is not permissible, then can we not pass a consequential order dependent thereupon?
Here, para 44, the Supreme Court exercises power under Article 142 for complete justice.
43 is Article 141.
No, well, it's Article
Paragraph 43 is Article 141.
43 and 44.
No, sir. No, madam. Not Article 142.
It's 44, they specifically use.
That is
powers
a
under
different,
142.
that's why I say Article 142 is a different. But 43 is 140. We don't agree with you. Read the judgment carefully. Cannot say it's under Article 140. Sorry. That's a consequence to follow. Nothing more than that.
Well, it's, if I may just request, my lords, what, because the pleadings and here the lease period had expired in 2020 and the present writ petition is filed in 2025, my lords, after 5 years. There is no explanation in the writ petition why from what was from 2020 to 25, what was the reason for not applying earlier, my lords. And here also the representation was only with respect to extension, my lords. And the prayer is also for extension. And my lords, most humbly, my lords, para 44, my lords, they specifically use powers under 142.
Madam, the difficulty is that you cannot decipher that it is 141 or 142 by use of those words. Simply in paragraph 44, the Sixth Court has said that I am exercising a power under Article 142. That does not mean that the earlier paragraphs are also connected there. Please consider the aspect. You have to read the judgment as a whole
Yes, ma'am.
and then find out whether there is any exposition of law on the basis of the facts and the submissions and the legal provisions which are there. 43 is a conclusive finding or a decision that has taken. The court in unequivocal words says that yes, if Rule 68 of that particular state rules does not empower the state government to extend or renew the lease, then the court cannot pass an order on the authority to do something which is not provided in the statute or which is beyond the statute. Then the court says that yes, if he was prevented for no fault on his part, that is the court very specifically says that no fault means there is no blame that he has done any illegal mining. There is no blame that he has committed any default. Nothing of that kind. But because of the interdict, then in that event, why not he should be entitled to a refund of his security as well as the advance royalty which he paid. This is a conscious decision. Comes under Article 141, not under Article 140.
And it's clear that conclusion had come because the state of UP had consented to that particular marriage. Para 41
Sir,
specifically.
what is the difference between a submission and a consent? Tell me, madam. There is a vast distinction between a submission and a consent being given to the court.
Here, if I may just read one
I
line.
am again saying, is it a concession? Because that is recorded under the appellant's case, respondent's case, under that heading.
Para 41, my lords.
Please,
This is what forms the basis of submission made on behalf of state.
this is an inference.
I'll just continue.
Please consider, this is what the inference the court draws from the submission of the authorities.
Thereafter, liable to refund such and such paid for this obstructed period, something to which the state of UP has already consented before us.
This is not a consent in that sense.
In that aspect, this court had
Sorry.
concluded.
Then why you are relying on a judgment which is on consent?
This
Then it is not exposition of law.
only for that period, Malus, if I may take a
Madam,
instruction whether.
that we cannot. That's why I say there is a consent and there is a submission. Both are distinct factors.
Here, if I may take an instruction whether.
But
this
nothing,
permissible.
we are
Because if
directing.
we have a
And this is
larger
a quite
ramification,
a reasonable thing which you should come. We will record our reason. Even if we do not agree, we do not take this decision. We will accept the principle of law which is laid down is that if there is no provision in the statute for renewal or the extension, the authority cannot be directed to do something. We will say, but we will equally held that if such situation arise and if it appears that they were prevented, then what should be the relief which can be extended to them? They can't be without any relief. So we will grant the relief. There is no difficulty. Sorry. This is more equitable principle which one has to understand.
Chance to take an instruction whether.
And second thing is the state is not supposed to take a plea of limitation. There is a Supreme Court judgment on it. You are a model employer. You are a noble government. You are not supposed to take a plea of.
The only request, my lord,
That the payment is time bar.
only to that respect, I was saying because the pleadings were not to that effect, my lord.
Whatever. These are the consequences that flows from there. Cannot the court grant a appropriate relief when the principal relief is decided? Can it not?
And there's only one,
Power is always there.
there's one chance to take an
No
instruction,
chance.
my lord. Whether this is, if this can be.
One chance. Only one chance.
If this can be done, my lords, by any, because it will have a larger ramification, my lords.
Obviously,
Thus, my lords.
what is expected that if somebody has committed wrong, we are absolutely firm that we will not permit that particular wrongdoer to reap the benefit. But if somebody who is apparently, there is no allegation by you,
That is not there.
there is nothing, then why he should be penalized? I fail to understand that why he should be penalized.
It's one chance, my lords.
That is a different. That is
There's
a
only
different.
one chance to take instruction.
No,
But then
nothing.
what amount?
You have argued vociferously, you have argued so forcefully. What more chance?
Because
No,
we
nothing.
have a larger ramification, my lords.
Nothing in the ramification. Pay back the money.
That only how much money is involved, my lords, that also.
That you calculate. We will not identify. We will simply say the security deposit which they have put to you, given it to you, and the advance royalty for the period they have not been allowed to operate. Pay back. That's all. You quantify.
Only one
You
chance.
quantify. We are not going to quantify it.
No, sir, that I understand. Only one chance to take
No
proper.
chance.
Only one chance.
It's only the delay.
So any day,
No.
my lords, next week also, my lords, any
Nothing.
day.
Next week is unnecessarily. Why you burden the court from dictating? We have invested so much of half an hour and then we can't dictate the order and it will be split over. We will spend another half an hour to dictate the order on that day.
I will remind.
That means what? No.
Only request, my lords, because.
No,
it will be
it's
done, my lords.
You have argued. You have argued correctly. You just give it to me. That we will decide. There's no difference.
There are also judgments of this court where this argument was also rejected, my lord, sir. I'm not carrying those.
I tell you, you have chosen a wrong bench.
I understand, well, it's my problem. I have read.
Throwing or hurling a hoax bomb will not do.
That if it consider.
I think I had more experience over there. What you have.
It is expected that when you open your brief.
Mr. Palit is leading that there was a stay with regard to that tender. So Lordship, only difficulty also.
Both the matters, your lordship stay, I think.
Item 42 of the weekly list is that matter. So there's an order of your lordship will uploaded brought to my notice just now by my learned friend, Mr. Mishra.
On 15 lordship, the lordship have directed
that,
that this
uh,
matter will appear with item number 42 of the weekly list. lordship.
That is how this is. I was called on a urgent basis. Lordship may take up because those from 42, they filed my counter affidavit and I have to file my rejoinder response. So Lordship may grant me some reasonable time, 2 weeks or 3 weeks to file the
Only
rejoinder.
difficulty is the interim order is expiring tomorrow, lordship.
That's obviously, my lord is.
Monday, lordship. Monday.
I was not. The other matter.
Monday. Lordship, this matter came up on Monday, lordship. The earlier writ petition was, order was passed on 19th November, lordship.
19th November, my matters, man. 19th November, when I was.
Stay was granted for a period of 4 weeks, lordship. That is expiring tomorrow, lordship. If that is not extended,
Man, thank you.
The instant matter is connected with the position number 3
Point is whether the financial fee less than 15% as is provided in the OPWD code. The matter was listed before your last Monday.
Yes, sir, the notice should go also in the meantime. Where is?
Mr. Avinash. Sir, Anthony, you are appearing in single and polio only.
Well,
Other parties are there. This notice, today's matter.
this matter already minor was
Already
directed.
served a copy.
The state council last up in the minor was.
Sir,
Yes, Mr. You're also directed for the detail. Yes, already.
Yes. Next for.
But this is that matter I just remind my lords, lord, the tender, where the OPWD code provides that a bidder cannot give a bid less than 15%, there is a cap in the OPWD code.
Yes, yesterday.
Even for yesterday, it was there.
And it was 18 point something if I remember.
Like this.
How can you do?
Lord, I have open instruction in this matter.
Thank you for that. I must compliment you.
That he granted me that 2 days occasion.
Yes. How can it be done if there is a prohibition which is created? Can you do it? Can you violate any of the conditions
Yes,
of the OPWD?
Level playing field is disturbed. We could have put it less than that.
But the nature of this tender is different. But I'm sorry,
Does it go outside the purview of the provision? Tell us straight away. Nature, I understand. Then we'll have to seek an exemption.
It's kindly.
I'm simply asking, where is the provision of the OPWD code?
But kindly see,
Is it an omnibus provision or it is?
it's an omnibus provision.
Where is that?
But I have given a copy, just now I am also further giving you.
No, this is the copy you have given.
Yes, sir.
Kindly see clause 36, my lord, page 247.
Yes,
Page 247, clause 36.
yes.
If the rate quoted by the bidder is less than 15% of the tendered amount, then such a bid shall be rejected and the tender shall be finalized based on merits of the rest bids. But if more than one bid is quoted at 14.99%, so less than estimated cost, tender accepting authority will finalize the tender through a transparent lottery system, where all the bidders, their authorized representatives, the consent executive engineer and you remain present. Now, your lordship, it's open provision. There is no restriction with regard to anything.
Now tell me that you can dispense with this. It does not really talk about anything else.
This tender is protect for lump sum amount. But you kindly turn to 42.
Where is the provision under the OPWD which says that in case of a lump sum, this provision would not come?
Code is silent about lump sum.
What is not said? Does it say that it will be only in respect of a specified tender, not a lump sum tender or anything of that?
My humble submission is that the provision of OPWD code which not is contravened.
No, my understanding is incorrect. Kindly see.
It will go, it is not, let's kindly turn to page 43 for a moment. Page 43. Page 43 of the brief.
Yes.
That's serial number 30.
Yes.
13.
Yes.
Bid price.
Yes.
The contract shall be for the whole work as described in surplus 1.1 based on the lump sum price bid submitted by the bidder.
Understand. Then
Now, Miller, the bidder shall fill up the total bid price as lump sum price, both in figure and words, for execution of the work on lump sum turnkey basis, including all items as specified in the bid document, Miller. Now, Miller, page
so the prices tender shall
Miller.
read.
The prices tendered shall except in so far as it is otherwise provided on the contract, include all constructional plant, labor, supervision, materials, erection, maintenance, insurance, profit, taxes and duties except GST and other levies together with all general risks, liabilities and obligations set out or implied in the contract. The lump sum bid price quoted by the bidder shall be fixed for the duration of the contract and shall not be subject to adjustment on any account. Now, Miller, page 69, let's say kindly turn. Page 69. Page 69. 13.2 Miller.
Yes.
The bidder shall fill the total bid price in figures online.
Which one? 13.2.
13.2 Miller. The bidder shall fill the total bid price in figure online as lump sum price. The total bid price shall be excluding GST on work contract. GST on work contract shall be paid by the employer.
Correct. So if somebody has said that I am quoting less than 18 point some, then it is not a lump sum price. lump sum price means once you say that it should be quoted in rupee, clause 14 at page 44. Please come. I accept what you say. Tell me, what is the meaning of this word? The currency of the bid and payment to be quoted by the bidder entirely in an Indian rupees. All payments shall be made in Indian rupees. So he has to quote that 5 lakhs rupees, 4 lakhs rupees, 10 lakhs rupees, a lump sum price he has to quote. Can he quote less than the estimated cost, 18.1%? Then it is not in Indian rupees.
Here, the cost is not estimated.
I do not know then how he has said that 18.87. Less than,
That's it.
from where he got this notion of less than 18.17%. From where he got,
That's it, Messi pays 925, Annex 6 million.
yes,
925.
9. Yes.
Annex 6 million. That's it, Messi, serial number 1.
925.
5. Annex 6 million.
What is this? They have to, there should be some.
Yes, ma'am.
The procedure that if yes, volume 1 and volume 2, if it contains more than
I'm sorry.
the 200 pages or a 300 pages, then it should be compiled in a different volume.
Henceforth, you will not commit to this.
DTCN will be separate.
He in fact, he has filed the entire DTCN which is not required. Still then, what I'm sorry.
Whatever, 9.
925, not annexes.
925.
I'm so
Annex,
sorry.
Annex 6 that. is. At serial number 1, let's see if we'll find
Yes.
the name of the person who is selected as L1. Let me see.
So figure
Figure.
estimated cost 0.
Million. And
Amount?
now let's see, come to the amount.
Yes.
BC Bhuya Construction has quoted million 175.
Whatever, number of zeros are
Number of
more.
zeros.
You can't read.
Million. Thereafter, Sunil Agrawal, that is the L2, the present petitioner, he quoted that one. It became L2 million.
What is this document prepared by you?
This is the document.
Who prepared?
This document is prepared by us.
Prepared by you. Why you have given in a percentage basis?
Only percentage is written there.
Why?
Let's say.
Must be in accordance with the OPWD.
Yes. Otherwise, lump sum.
This is clarified in the subsequent tender committee meeting resolution. I have given. Along with the instruction. If I publish thing, then I will file an affidavit.
What clarification which made?
Let I have marked. That's it, kindly see the annex of 5 of that document.
What about the last paragraph or penultimate paragraph of piece 3 of your instruction? In this connection, it is to state that the action of the opposite parties are within the purview of OPWD code and terms and conditions of RFP document. Then OPWD code, does it talk about any distinction between a lump sum price and the other price? No.
Let annex of 5, that's it, kindly see of that instruction.
Of
That instruction, annex of 5. Last but one document. That remark column.
yes.
There is no percentage.
Where
Annex of 5, that's it is what.
I am looking at that.
That's it, my similar. The bid rank L1, L2, L3, L4, L5. L6, L7. And there is no percentage here.
What? This is annexure five.
No, Milord. Correct.
Whereafter the annexure six.
Let's see first. Next.
This is annexure five. Going to. This is annexure five. No, that you showed it to me. Yes. That you showed it from their document
Let's
also.
see, kindly see annexure 6 of that document. This is prepared, Milord, after opening of the financial deed. Now the document which is under annexure 6 is different, Milord.
What?
Let's see annexure 6, Milord.
I'm looking at the next page.
Annexure 6 of this brief.
Of the brief, Milord.
Brief,
Yes,
not this.
not. Let's see tally this one and with the annexure 6 of the brief.
No, I have
So
seen.
that there is a descending brief.
Yes, Milord.
That figure and.
No, here the percentage is given, here the percentage is not given.
Yes.
I have seen.
Perhaps the committee has taken that.
They-
Where they have calculated this percentage.
How you have awarded the contract? Show me the decision taking the contract, awarding the contract.
The contract is not awarded yet, Milord. Contract is not awarded yet, Milord. It is not awarded.
Where is the decision for declaring him the L1? Where is the decision?
Yes, Milord. Kindly have a glance to annexure 4 of that document I have given, Milord.
Yes.
Annexure 4 of that document which I have given now, Milord. That is proceeding of evaluation of technical presentation for the work. And thereafter, let annexure 6 of that bunch. That is the approval from the government.
What is this?
Government Works Department letter number 15/12/2025.
Detailed?
15/12/2025.
The day your lordship took up the document. Yes, sir. I've seen that. There's a letter you do not do. There's an actual 6 is 15/12/2022. There's a letter. Yes, sir.
In fact, if the Lordship would see, last year Lordship took out the matter on 15/12 itself. And on that day, and the State Council took time.
I understand. The point is very simple. He is trying to make a distinction that if the price is to be quoted, there is no estimated cost of the project. Then in that event, how one can work out a percentage basis. He says that there is no question of any percentage basis, it's a question of the quantification of the amount to be quoted for the completion of the project. Since the other side has quoted the lowest price, he has been awarded the contract. Your contention is that 15% or 14%. From where you got this percentage basis?
Yes, sir.
From where you calculate?
Yes, sir. Your Lordship may kindly turn to page 919.
9,
Annexure 4.
9,
919 Annexure 4.
19.
Right, but 919 of our brief.
Yes.
And this lump sum theory is also covered in the OPWD code. I'll show to your Lordship.
Sure.
I'll show you. 1 second of this. Just kindly see first page 919 Annexure 4.
Yes.
Serial number 7. Amount put to tender.
Yes.
Rupees 215.40 crores lump sum.
Yes.
That's got it, man.
Yes.
Now, your Lordship, see, OPWD code also covers this lump sum aspect. Kindly see, Lord, if your Lordship has it book, kindly see. In a given, is your Lordship cannot have that book. Here. Kindly see, OPWD code also covers lump sum and also provides para 36 by your amendment.
Where?
At the top, your Lordship will kindly see.
Yes.
And identically lump sum tenders also they have rejected. I'll show you, Lordship, not applying OPWD code.
No. If contracts, it does not talk about.
No, the less.
These type of contracts are given only in exceptional cases.
Right, exceptional cases.
Correct.
Now, clause 36 also will cover and lump sum para doesn't exclude clause 36. And I'll just show you, Lordship, one page. Annexure 9, your Lordship may just see. Annexure 9. An identically placed lump sum contract, they have applied para 36 and rejected it.
Where page?
931. Kindly turn to it. But this is another tender of lump sum contract. They have rejected it on this ground.
Sure.
But where this petitioner was also a bidder, kindly see page 931, 10th of July 25. And
It's on a turnkey.
this is also turnkey.
Hmm.
I am directed to invite reference to letter number source on the subject cited to say that government after careful consideration decided to cancel the tender and requested to go for fresh tender. Bid amount quoted by L1 bidder is 17 so less than estimated one, more than 15% less.
Yes. How can you take
Apply clause
a
36.
different decision in this? This is also a lump sum
Let
turnkey project. And
Yes.
this means they have to provide everything.
Everything.
that matter, Millard, I have got instruction. It's done wrong.
You were given a copy and he's taking there that you can't make a differential treatment
Yes.
in this regard.
This level playing field is
Then,
disturbed.
you file your opposition, but we will
Yes.
pass the entry
My
order.
humble submission is that Millard, once that wrong is committed, that wrong cannot be
Correct.
repeated.
Which one?
Can you wrong, say wrong?
That annex.
You come and say that this is wrong
Then allow me to work here. I am also a bidder here.
and then say that this is wrong. Come and take.
That is not fair. Prayer.
He's taking a disparity, the discriminatory action, which is one of the hallmark of Article 14.
Yes. Level playing field is disturbed.
Disorder will say, it's not a level playing field. Level playing field is something
With
like
your lordship. I know.
this is a discrimination.
Discrimination, clear discrimination.
Per se discrimination.
You can't kill me of both the ends.
You can't you apply the rule 36 or whatever, the clause 36
Yes.
and suits you
Yes.
arbitrarily. Arbitrary.
Millard, I will file counter video.
Subodh Kumar Singh Rathaur's case.
Yes.
Of the Supreme Court.
Yes. So grateful.
Of 2024.
23,
25.
23, 23,
24.
24.
AIR 1924.
Yes.
I'll file it affidavit.
Fine, but This is the clear piece. This is these solitary points.
Yes, we have.
Notice to it.
OP 6.
OP number 6. And so, he will do it in a proper manner. Next time he will supply in volume. I'm sorry, sir. I'm so sorry.
It's not expected, sir. It should be there done in the volume.
Landed print is experience.
1, 2, 3, 4, whatever.
That should be.
And you know it has come out. The pages have come out.
Next time you will be careful.
Should be separately. 11 pages, 3, 4.
I'm so sorry.
I'll take the name.
Great, sir.
Item 5.
Challenge here is to the judgment dated 20th September 2022.
It is filed.
Yes, my launch, the friend is appearing in the VC. Already the delay has been confirmed.
Yes. So it's for admission.
Yes, ma'am. Before I proceed to the impugned order, we need just.
Your Lordships, may I have 2 weeks' time to file a counter to this appeal? Because I would have to take my lords through certain case law that have been referred to by the learned single judge. In fact,
Counter affidavit, sir. This is
yes, my lords. Yes, my lords.
We completed a pleading in the trial court. So definitely what more counters that you will class. Only it has to be heard on the touchstone of the legality of the order.
Very well, my lords. I just thought I would be in a better position to assist my lords if I could put a short.
Here, before I proceed to the impugned order, may I just write in facts and very notes, sir. On 10th of July 2023, an award was passed by the MSME. It's an arbitration award. That was challenged under section 34.
So this he is appearing for the
IOCL.
Yes, for Indian Oil, my
Please
lords.
go home.
As a respondent.
Respondent.
So let us fix a date for hearing of.
But I have an objection.
What objection?
My
For hearing.
No. My
Your award has already been set aside.
But that's exactly my.
You can't expect the interim order to be passed in such a fashion. If you say that, that means that the interlocutory stage, the entire order is revived.
No, my lord, I'm not saying. No, what I'm saying is this, my lord. The determination was against them as per the award. Now, after setting aside, they have now taken my bank guarantee. 5 crore.
We will see to it. If
My lord,
suppose can visualize if this order is set aside, then definitely all the consequential steps which they have taken has to be reverted back.
They are taking away my 5 crores rupees and I will be in nowhere. I will be exiting my lord as an MSME.
5 crore is a bank guarantee. Which
The bank guarantee they have already taken.
Then-
Now from the bill they are going to recover 5 crore rupees on risks and cost. And my lord, this is the matter covered by your lordship's decision.
maybe.
May I just trying this?
That's not enough.
Me? My lord, just filed after period of limitation with the unconditional. After that, this writ application has been filed and urging upon the grounds which has never been taken before the trial court. And now the honorable single judge has appreciated the contract which is in the domain of the arbitrator.
Sir, what is done, sir?
My protection, my lord, at least.
Sir, your entry prayer is restricted to the invocation of the bank guarantee.
No, but at the second prayer I have made that.
Where is the prayer, sir? At the, I have seen that.
I have filed.
Two IA you have filed.
The second I have filed
I
that.
do not know where is that second IA. See the operation of the judgment.
For recovery,
Nothing, sir.
they are insisting for recovery, my lord. That's right.
So, sir, there is no prayer. Sure, sir. Two applications I find, one is for invocation, another is for stay of the office.
Well, in the last, I also can see I've stated.
Sir, where is the prayer, sir, shows? No, sir. No.
Lordship,
No, I can't mold the relief at the first instance. Supreme Court judgment is there. A court can mold the relief only the relief's claim becomes diluted by passage of time, not at the time of an admission.
my lord, may I just try with one. Hey, what is happening, my lord?
We are fixing a matter to.
My lord, it's a MSME, my lord.
Whatever, MSME, but,
My lord, see.
uh, Mr. Matthews appears for the respondent. And they service of notice. You have been served with a copy. What was this proceeding which was initiated against you?
That is a caste certificate proceeding. Caste certificate proceeding.
No, then during that particular investigation, whether you were allowed to continue or you were not allowed to continue
I was continuing. I was continuing.
till
Till that order has passed. Till this order,
yeah.
that is on, that is
Where is the order of 7/3,
My lord.
2025?
page 28. Till 12/3/2025, I was continuing.
So it was only a direction to dispose of the proceedings.
My lord.
There was nothing.
No. I was in job. I was continuing till.
No, when the show cause notice was issued, before that any suspension or.
No, my lord. I was absolutely continuing with all benefits. Till High Court.
Then where is the subsequent order, which is, the court has said, which is subsequently set aside?
My lord, that is. Page 46.
9/5/2025.
Page 46. There is Annexure 7, ordering person, page 46.
Issue notice.
My lord. May I make a prayer, my lord? Interim cannot do. I know, my lord. But your lordship may consider.
No.
I am out of job. No, I am absolutely.
You will get it. We will see to it when the final release.
That is only prayer.
Seven.
OP1 मिल
7.
Item number 7.
My lord.
Item number 7.
Yes, item 7, I have filed two applications for intervention.
What is the subject matter of?
The subject matter actually, read application has been filed to direct the sub-register not to register the sale deeds presented before it, keeping in view of the new act that has come into force 2023 regarding development authority apartment ownership registration act. If you also look at the prayer in the read application.
They say that why don't you follow the provisions of the Orissa Apartment Ownership and Management Act?
Yes.
And also not to register the sale deed of the residential apartments.
Right.
In absence of offensive certificate and registration of the association.
So this act was amended. Previously 82 Act was there. This 23 Act came into operation repealing the previous act. But this act came into force because of RERA Act, Real Estate Authority Act. That came in 2016. It operated from 1/5/2017. There is a specific clause. Any building or apartment constructed prior to that got the completion and occupancy certificate. Those will be not applicable. RERA Act will not be applicable. Now this act has been made to regularize the RERA Act itself. It cannot be made applicable retrospectively. Correct. But if you also look at section 2, section 3 of that amendment act.
Section?
The section. Right.
Attach the copy of the act at annexure 5 of the requisition. I have attached copy of the entire act. For annexure 5, page.
This is 1984. What is that?
Yes, sir, section 2, well, section 2.
The definition section.
The provisions of this act shall apply to all apartments or buildings converted into apartments irrespective of whether
their construction made before or after the date of commencement of the act.
So this cannot be said to be
Prior to 2000.
prior to 2016.
Correct.
Where is the object to just no. It came into force on 28 June. But section 3 applicability was applicable before. Well, this contingent is that before I understand, but there are cases because there are sales prospective effect, not restrictive. This restrictive and is restricted to the coming in force of RERA.
So in fact, section 34, let's we kindly see. Of that new act, 23 act.
How to remove difficulties.
Sir, if any difficulty arises,
The state government always have.
the provision of this act, the state government may by order publish in the official
The
gazette.
state government is always given the power to remove that difficulty.
Right. So they have issued a notification. That notification was tried to be incorporated by way of amendment. Before allowing that amendment, but the notification wanted to clarify not applicable to prior to 2016. So that has been, the Honorable Court has passed an order directing the authorities not to register initially. That order is there. As a result of which, for individuals aged about 75, 80 years old, not able to sell land for purpose of their treatment. That is one of the cases I have also filed an application. Those sale is being affected.
When is that case? In which matter the order is passed not to affect or allow the registration?
Registering them not to transfer, not to register the sale.
Where is that order?
So in this writ application.
This is the matter.
Yes.
You are coming against the interim order or final order?
I am before your lordship to intervene in the matter so that the.
I mean, they have come up, the petitioner has come up against the final order or interlocutory order?
No order, sir. No order. There is final PIL type case.
Oh, sure. This is the WP.
It's mine. There is no order as such.
There is an restraint order passed here.
Yes,
to register.
Right.
Order number 4. Order number 4.
Order number 4.
Can you show me the bill of this apartment then?
Yes, yes.
Bill.
Bill. The objective reason is there.
In a very concise manner.
So actually, this act was enacted when a PIL was filed for this court. Number of cases were filed, and while during the pendency of those writ applications, the Honorable Court directed the state to enact the law. That is how the law has come to force.
Directed.
Sir, government said that we are going to amend it.
When you say the court directed, that's why I asked. Very active to it.
Sir, directed that is the previous law may not be applicable. Government said we are going to amend it.
You have the bill? You have the bill?
But in the meantime, they have already notified it.
No, that notification is not the clarification inside.
December 2020.
No, that is not.
That will
That is not in.
brought to the.
What is this?
My inspection whether this is widely covers the issue.
Resale. So that notification, there is a flaw alert. It says resale is permissible. Yeah, that is sure.
In fact, we have prayed for a stay of that notification in an IA that has not come on record, the petition.
Objective, because this has also come. And there has, the government has really clearly indicated the reasons for enacting this law.
Right.
The reason has been assigned that we wanted to bring that this RERA Act in tune.
In compliant to it.
In tune with this act so that it is implemented with full vigor and force. RERA does not say that any apartment which has been constructed prior to the coming in force of the RERA will also apply, will come within the purview thereof.
Absolutely.
It is an optional. If somebody wants to come under RERA, he can come. But if his commencement has started earlier, then question would be then that if the object and the purpose supplying this particular incorporation is very clear, unambiguous, then why not this act will have a restricted retrospectivity and will not apply to a apartment or the construction or the real estate, you know, the
Project.
the project which commenced prior to 5
Which were completed prior to
2016. Why?
Only two provisions I will show to your lordship. Section 8, subsection 2. Act itself clarifies it.
What?
At the time of registration of a sale deed, what documents are required? Subsection 2.
Sir, probably you are not understanding what is happening, what is playing in my mind.
Right.
First thing is that we have to first understand applicability of this particular act
Yes.
to a project which commenced prior to 5/10/2016, or the sale has already been effected, or allotment has already been made in the apartment prior to 5/10/2016. First, if it happens, then the applicability will come. You say whether it has an unbridled retrospectivity or retrospectivity is in fact a retroactivity.
Yes. My lord, because prior to the RERA Act in the state of Odisha, the Odisha Apartment Ownership Act 1982 was there.
Correct.
Under
was
that,
there any brindle in that 82 Act that no registration can be done without an occupancy certificate?
yes, sir. There was an amendment in the year 2015 that also have annexed.
I am asking, suppose amendment has come, whether the legislature wanted this amended act to operate retrospectively.
That, sir, my lord, section 2 clarifies that it applies to all apartments.
No. Section 2 says that it will apply, this act will apply irrespective.
Yes.
Whether the construction made before or after the commencement of this act.
Yes.
On a freehold.
Yes.
Now this interpretation requires whether their construction made before means before 5/10/2016 also, or on and from 5/10/2016.
When this act was enacted, the RERA Act was already in force. It was before the Odisha State Legislature that the RERA Act is in force. If they want
That came into force on 5/10/2016.
RERA Act, yes, and this
I
act.
am asking any project which commenced prior to 5/10/2016, what would be their position?
They are covered under this act.
Now tell me, show me the law, which because you have to then satisfy us that how it can be.
My lord, because there is an exemption under section 8(2) that if a project doesn't fall within the RERA, need not give that certificate of RERA to the registering authority. There is an exemption.
So anybody who has purchased an allotted land
before
so
that,
we can say before
yes,
5/10/2016, and no occupancy certificate,
no, my lord,
registration has to be done.
it's a question of RERA certificate. He need not go under the RERA to register it.
Was it mandatory prior to a project which commenced prior to coming in force of RERA?
No, my lord, prior to coming in force of RERA,
Question here, what he is raising is that in an apartment which was constructed or a construction commenced prior to 5/10/2016, whether those constructions or those apartments will come within the purview of this 23 Act or a RERA Act? I'm asking.
my lord, it will come within the purview of this act, not RERA Act. Both operate differently.
If this act is aimed to ratify or make a provision of RERA to come, then in that event, can you extend it beyond the commencement of RERA?
Act has been enacted for the purpose of this act and RERA Act. Section 14, your
So
lord.
again, I'm saying the question is can't throw in the air this one. It is as a pertinent thing because I have seen those constructions which have come prior to the commencement of the RERA. There was no compulsion on their part. Even a commencement continues.
Yes.
There was no obligation on their part to get themselves registered under the RERA.
Yes, absolutely, your lordship. So the RERA certificate is not required for a registration, but an occupancy certificate is
Sir,
absolutely.
Again I'm saying, there are two aspects. When the act which was in vogue at the time of commencement of the project or the construction does not mandate the occupancy certificate as condition precedent for registration of the deed, can you invoke this provision retrospectively? That's the only question I'm asking.
It mandates the presence of an occupancy certificate.
The law which was invoked,
In
it says that the occupancy certificate is required, I know.
Yes, in 2015 it was there.
For the purpose of registration,
Yes,
I'm asking.
for the purpose of registration, your lordship.
82 Act, show me.
Yes. Your lordship may.
Sir, that certificate was being granted by an architect. Now, because of change law, it has to be obtained by the competent authority.
Just to.
I have annexed the amendment by idea number
I am
1.
asking the parent tax.
Just to add to your lordships, what in line of what your lordship has said, but the concept of occupancy certificate itself, the concept itself, was inserted to Odisha Development Authorities Act, the Parent Act, only in 2015. Not before that.
2015.
Section 20A, my lord may see ODA Act, section 28.
That's why I say amendment has a retrospective effect given by the legislature.
No,
if any project which is completed or commenced in 2010, 2011, 2012, 1982 Apartment Ownership Act was there. Does it contain any kind of a stipulation? That is what I wanted.
Even the concept of occupancy certificate itself came in ODA Act in 2015. How can
it show from there?
That is what I was saying.
It came in 2015, sir.
It's inserted in 2015. Well, in that light, also see ODA Act. Odisha Development Authority Act.
38 or.
Yes.
Well, 35 is there. 35 is the bound.
That it is mandatory for the purpose of registration of the same. Sure. Which province?
The Odisha Apartment Ownership Amendment Act 2015.
I am talking about amended act.
Amended Act.
I mean, sorry, Ownership Act of 82.
In the original act, it was not there. It came in.
Not there. So that is what I really want.
It came in the year 2008.
Which one is the amendment? You show me.
My lord, it came in the year 2008 in the
Says 15, now you says 8, show us. Show us.
regulation 66.
Talking about regulation. The Lordship is asking the parent act. Parent act is 2015.
In regulation 66 of the DDA, it was framed under the ODA Act. DDA Planning and Building Standard Regulation 2008. It says no person shall occupy or allow any person to occupy a part of a multi-storied building unless such building has been granted an occupancy certificate.
Correct.
Yes.
Suppose this is a person has violated and come in the occupancy.
Yes.
It only prohibits an occupancy. Does it prohibit a registration of the same?
My lord, for an immovable property to come into being, someone has to satisfy that the building is there. Some property is there which can be sold.
You are before
My lord.
you are before a remember. Yes, argue.
My lord. So without an occupancy certificate, a person cannot get an electricity.
What is the definition of an immutable property?
Thing which has been permanently attached to the earth.
Its only thing is the immutable property. Under the General Clauses Act, the immutable property is defined. And what is the transfer of property under section 5 of the Transfer of Property Act? What can be transferred? When you talk, there are two concepts, I visualize this. What you say under the General Clauses Act, the immutable property is defined, anything which is permanently attached or portion to the earth will be regarded as a real property. The Transfer of Property Act is the central act. It talks about all the property which will be movable or immovable in respect of any land or in respect of anything which is there. When you talk about a transfer, then in that event, the transfer should be effected as provided under the Transfer of Property Act from a living person to another living person, from a living person to a association, from a living person to another, in presently or in future, not antedated. Section 5 language is either in present or in future, not antedated. Now the situation is once the registration is under section 17 of the registration. If there are certain documents which is compulsorily registerable, then in that event, it cannot be granted. The law says that any property which fetches a value more than 100 rupees, immovable property fetches the value of more than 100 rupees, is compulsorily registrable under section 17 of the registration. Section 17 of the Registration Act does not contemplate that what document should contain in the deed and what should not be contained in the deed. It does not talk about anything. It simply talks about that there should be a price, or under the Transfer of Property Act, it should be a price. There will be a property, immutable property owned by somebody who wanted to sell it to another person, transfer his interest. Nothing more than that. I am coming, again I'm saying, don't go in other way. We are coming vis-a-vis the right of registration. The moment is willing seller comes and presented the deed for sale. Is it within the competence of a registering authority to find out the title or decide the title? Say that the person who is executing the deed, he is the person who is executing. Only the identification of the person and the seller who is coming. Nothing more than that. Now question is, occupancy certificate, is it such a vital piece of document which will impede the registration of a deed? It may invite certain consequences so far as the occupation of the property is concerned. Am I not entitled to purchase a property and may not be in occupation thereof?
Absolutely.
So, if my occupation goes, that does not mean my title, rightful title to the property goes. This is what
So your lordships have
The delay of 84 days. Service. Some intervention applications have also.
hearing.
We have the intervener.
Why are so reluctant in the hearing? Intervener will consider this later on. Review intervener.
You're the beneficiary of the order.
Tell me whether the intervention in the review is permissible.
So they have.
It is not a rehearing of the matter.
Fine. I do understand you, Lord. You understand, okay.
Which for the
State has filed the review, my lord. I am for the respondent number 1 and 4.
The respondent number.
1 and 4.
you are the writ petitioner.
You are the reporters.
Yes, my lord. We are the petitioners.
Have you been served with a copy of confirmation application?
No, my lord.
You are not served.
Sir. Oh, telling presence of 1 year. I'm asking you whether you are.
Item 9.
Notice to these appearing for 2 1 and 4.
1 and 4.
Notice.
But
There is nothing.
Item 9.
in fact, this thing that has always been had by the lawsuit on last public government. So relates to opening of retail outlet.
What? We don't actually. What is this?
Here, my lord.
No, we wanted the interim letter stated 11(3). Where is that? Section 7?
Section 7. 11(3). That order has been passed pursuant to the direction passed by this honorable court in the earlier reports. In fact, after that order was passed, no inquiry has been conducted. Whatever inquiry was there earlier, that is prior to filing of the writ petition, they just enforced those inquiry reports.
No, you are challenging this Section 7. If 39, but this is the Section 7, not 630.
Page 29.
So he has inquiry reveals that the submission for opening individual outlet has been granted. That's all. Then why?
That we are classifying on the ground.
So that's
What about you are going to open the retail outlet?
When appointing.
Oh, before who? Who are you?
What had happened? In fact,
Who are you? Just tell me.
So I am at the locality.
Locality. locality is coming under the panchayat or it is something outside the panchayat?
No, that within the panchayat.
Within the.
Yes, that
Have you chosen the
yes, yes,
sarpanch or you have not chosen the sarpanch? I'm asking, have you chosen the sarpanch or not chosen the sarpanch?
That is true. The
So,
sarpanch has given
once the sarpanch has come forward and says that there is no objection from his end, you being a lone person, will you come and stand in the way?
No, that is not.
He is chosen by a majority.
Yes,
So
yes,
that will be regarded as a majority decision of
that
the.
is one of the criteria that sarpanch has to give the NOC.
So he has
From
given
that
an
manner,
NOC.
the city criteria have to be followed. The city criteria has not been followed.
No,
the inquiry
it's a
report.
opening of a new retail outlet, sir. It's the opening of a new retail outlet. It's not a shifting.
Not the question of shifting. It is new. But it is in the locality which is not permissible. Lord, you have a glance. The inquiry report, the inquiry which was conducted prior to the order passed by this honorable court in the earlier writ petition, Lord will get at page 31. Page 31, the inquiry report.
Yes.
That inquiry was conducted without taking into with the behind the back of the petition.
Why? Who are you? How powerful you
Because
are?
my lord, they invited objection under annexure 1. We the villagers or the local people, we submitted the objection.
Within the
So
time?
they should have
Within
given
the
up.
time or without the or outside the time?
Now within time, ma'am. Within the time and without giving them an opportunity.
Show me where is the notification inviting of the
Annexure 1, page 16. That was by the ADL.
whatever. Let us see.
That is
Yes, where is the objection?
Objection was the next page 17. It is an OVR. When it was not considered, then annexure 3. When it was not considered, then we file another petition.
Where is a document showing that you have really completed on 29 votes? Where is the receipt? Shows. Where is the receipt showing that you have submitted?
Postal receipt matter that is there.
Postal receipt show me the
Page 19 or so.
show me the date.
22nd of May 2024.
And this is the letter of 29th court. So nearly more than 25 days we took.
Yes,
to dispatch.
in fact, 30 days time was spent to file objection within 30 days.
See, that's why I am asking these questions.
Yes, sir. It is within time. But while conducting the inquiry or obtaining the NOC from the sarpanch, but those people who submitted the objection, they have not been given an offer. At least the inquiry should have been.
They raise an objection. Now.
Oh, that's okay, number 5. Yes, me, my lord, the outlet is.
Your outlet.
Already half of the completed, my lord. Already half of the constitution is completed. That my lord, the stay of status code passed by this my lord.
This is what the authority have done. Annexure 7 below page 29. Personally, my lords. Not a inquiry was conducted, not a requirement. They wanted that there should be, everything is done, they should be there. They should be heard, my lord. That is what is the grievance, my lord. Previously, they have come before this honorable court. An order was passed, my lord, at page 26. Let's me kindly see. 27 is the operating part. The paragraph number 4, my lord. It was only directed. They also, my lord, their grievance was that their objection was not being disposed. No order is being passed. So, my lord, this honorable court directed that we will communicate the order. My lord, according to this order, my lord, they have to be communicated. The counter is silent so far as opportunity of hearing is concerned. Oh, so no personal hearing was afforded, only for the information. The information has been given to you. But information has been given to us, my lord, but if it is not contemplated, why you did not approach the court and say that we should be heard?
No, at that time, it was not within their knowledge.
That's what you're talking about. You are saying that they are proceeding without anything. You have filed an objection. That is the reason you approach the court.
Yes, right.
Must be a prayer for affording an opportunity without hearing. The court has said simply information.
Yes, earlier order.
And now you have raised certain issues. The inquiry report says that whatever you are saying is not there because everything is beyond 50 meters.
At that time, my lord, it was not within our knowledge.
Which is the distance. Yes, my lord. That as per the central government guidelines, my lord, all the rules, my lord, everything has been taken care of. My lord, there is no deviation at all. 50 meters distance from the school, hospital, from the gas lines, everything, my lord, we have available.
That is the reason why, lord. Had we been given an opportunity, you could have applied the authority that how it is not permitted.
It is there. They have gone there and made an inquiry and they certainly
given
all that in writing in the objection that given in writing. All their objection, my lord, we have verified all these facts. You made a team, my lord.
But in our absence, it has been done. We have not given an opportunity.
Every time the prejudice cannot be done.
Paragraph 1, the submission is recorded. 12 to 2015.
At that time, it was not within our knowledge that such an inquiry has been conducted or any report has been submitted.
This inquiry was conducted subsequent thereto. Which order is of 12 to 2020. Oh, prior thereto.
Yes,
2012 2. So you are simply says that you should be informed. You are informed. And above all, the Sarpanch has given the objection.
Now, mother, the checks on the NOC given by the subjects of the Sarpanch. That is not the point criteria.
No, I understand. But after all, in a democratic polity, then in that event it has to be.
And my prayer, madam, your lordship may give only to conduct a fresh inquiry in presence of the people and complete it within a particular period, madam.
Correct. To show a bona fide deposit a particular sum of money, I am directing you.
that in the event your actions is not sustained, then the loss which he suffers because of you, who will compensate? We have to bring the equity. If the equity goes in your favor, the equity should not be one-way traffic. It should be a both. So you deposit a sum. We are directing you to deposit 10 lakhs of rupees to the court, and we will hear out and set aside this and direct a fresh inquiry to be conducted in this case. Your preference. Show the bona fide, deposit 10 lakhs.
Lordship may call it day after tomorrow, I will take instruction.
What is, we are directing you. If you do not deposit, they will continue.
Now only day after tomorrow, Lordship, because
Nothing more.
I'll try to.
Equity has to be
that
balanced both ways. Was it? We're directing you to deposit.
Lordship, day after tomorrow, I will take instructions.
We are directing you to deposit. You can instruct them.
If
If they cannot, then it's better to go.
Because you don't need to.
Then how can the authorities have gone there, they have seen the sarpanch of those village has given
that is a
what more, sorry.
Day after tomorrow, Lordship,
We are directing. If you come with the day after tomorrow, we are fixing. Come with the money of 10.
I cannot because
How much you have invested?
around 1.5 crores.
10% PLC. What more equity one can show in your favor? Less than 10%. Only 5%.
The day after tomorrow, I will pay the Lordship, or I wait.
Nothing.
Day after tomorrow, I will fast case my Lordship.
Tomorrow is my brother, I am not.
Item number 10.
Petition of petition of state are not used not on this matter. Neither they have served a copy of that petition of state petition, nor might they have given reply to my affidavit as indicated.
Filed and so copy has been served, what noted is we have.
No,
And
petition of
another
state
copy I
petition
can
has
give.
not been given.
It is not a issue that in appeal they have got an interim order against the Union of India.
And you will also kindly see the order dated, my lord.
This is a one line order has been passed in IITC. They have
complete you will be the. So lordship may kindly come to order dated 18/2/2045, paragraph 3, my lord. Mr. Kumar, learned advocate of Central Government Council, you will also get that order, my lord. Government Council appears on behalf of the Union of India on query from the court regarding how his client was misled from or him to show that an act of his client would indicate such. He seeks adjournment as the application and affidavit copies have been handed over to him. The market rate for interim protection on submission his client has since been called upon by letter dated 13/2/2025 to submit the final representation on punishment. Late on least it on 11 March 2025, the proceeding for the imposition of punishment will remain state in next of hearing, my lord. They have not given, my lord, the reply to the affidavit as they have taken the time.
If they don't want to give reply, my lord, I am ready to argue the matter.
Let them argue. My lord, I want to conclude this. Let them argue. Let me conclude because they have got an interim order of stay and they're enjoying this care as a
He do not this I think figure out from the minute of the order. 18-2. Who was misled?
How this observation.
Before that paragraph, Lordship may see the paragraph 2, replying on the document disclosed by the aforesaid affidavit, dated 17 February 2025, he demonstrates his client was all along treated as belonging to the general category. All more it says the client could not be said to have been misled to authority. That means
Can he said to have misled the authority means you. You are the authority. He says that he cannot be said to have misled you. Then why 3%? Please come.
Yes.
Mr. Kumar, the learned advocate central government appears on behalf of the Union of India.
Yes.
Then, on query from the court
Yes.
regarding how his client was misled, means what? You never said you are misled.
No, I haven't said.
Then, for him to show that an act of his client would indicate such, he seeks adjournment. What does it mean?
My lord. That way, filing an affidavit, my lordship may see. That is.
Yes, please, your case, sir. What is this? This is the writ appeal.
It is sir from 33.
Your writ petition has been dismissed.
Dismissed. You lost it.
What are the ground? Where is the impugned order?
Impugned order under
If
Order by the honorable civil judge.
well, mind. Then you give reply.
You can press.
What is this SEBC committee?
It's really an educational backward class. SCBC.
What is the wrong? Proceedings is still pending.
Still pending. Because of the stay order, we are not able
there. Who there?
My lord, you lost it. Thank you.
What was the prayer in your petition?
Restriction, my lord.
What was the
I paid 29. It is how to quash the memorandum of charges. To quash the memorandum of charges. You lost it. Kind come to the memorandum of charges at page 56, my lord. At 57, my lord, the article of charge is there. That CIS number so and so, DD Ramesh Chandra Mohanty of CISF Unit Nalco, Damanjodi, during the recruitment process for the post of constable, DD in CISF falsely represented himself as OBC candidate with an intent to mislead the department for personal gain. Consequently, he was appointed as constable.
Yes, the charges are very straightforward. That you have claimed yourself as an OBC candidate at the time of me securing the job, but you are not coming under the OBC. You are coming under the SEBC.
Yes.
SEBC.
Yes.
And then will have to be, you go and show that what was the condition at the time of recruitment, whether you applied as a OBC candidate or SCBC candidate or as a general category candidate. Show us from your applications and all that. When the court will interfere against the article. Please appreciate the law. First tell us when the court should interfere against the article of charge.
Article of charge is that
When can court interfere?
my lord,
Show me the law.
Case of record, my lord, on the case of record. I have filed the affidavit to which they did not reply. I was recruited as a general candidate. General candidate.
Again, I am saying article of charges. You may have a good defense. Go and prove in the proceeding. Let the proceeding be quashed or be dropped. Everything will done. When you are challenging an article of charges, then what is the scope or the jurisdiction of the writ court to interfere and quash the article of charges?
When I was not recruited as an OBC candidate, my lord.
Is it not a prejudging an issue?
Before initiating an inquiry, my lord, they wrote a letter to the Tahsildar and Collector Kendrapara as to what is my caste, my lord. What certificate I have produced, my lord. I produced an SCBC certificate before them, my lord. At the time of recruitment, that document is here, my lord. I have to do that. The Tahsildar reported that the certificate, caste certificate, which was SCBC, my lord, was produced at the time of recruitment. It is a genuine document. There is no misleading or no false. I produced my lord. I have given the SCBC certificate. You have not recruited me under the OBC category. From the beginning of my service, I was given appointment as a general category candidate. I have given the documents. They have not denied it, my lord. They have not denied my
Again, with folded hand, I am saying
only that
you are challenging the article of charges.
When
You
it will be
wanted it to be quashed. Now, at this stage, what is the scope or what is the jurisdiction and what is the law which the 226 court applies?
My lord, you lordship keep it day after tomorrow. I will give it like
I have multiple judgments against this concept.
My lord, I am satisfied under this factor.
Yes, I am dictating. You keep this judgment for future reference.
No, my lord, your lordship keep it tomorrow. My
Keep it for future
I
reference.
let your lordship keep it tomorrow.
That at
Keep
the
it
show
tomorrow.
cause or at the article of charges stage, whether
Yes,
the writ court should interfere.
Tomorrow, my lord.
If it to interfere, under what circumstances it should
Yes,
be.
kindly tomorrow, my lord. Kindly tomorrow. At first case, my lord, tomorrow. My lord. At first case, tomorrow.
You want a ventilation to be put in.
Tomorrow, my lord. Kindly tomorrow. Tomorrow and first.
Tomorrow, first matter.
Yes, my lord.
First matter tomorrow for dictation.
It's a matter for years.
Yes. First matter tomorrow for dictation.
And during my
Other judgments, there are many judgments you can be looked at.
I find out myself. Under this circumstance, I does not.
No single judgment you can be read.
Annexure 8 and I made apparent by way there is sufficient to peruse my lord and pass necessary order. Annexure 8.
Item 11.
Should be prejudge an issue. You are there to take.
My lord, it is only 25 days delay.
Oh. Have you served? Have you served the copy on the other side?
No, I'm not done.
Sir. Notice, yes.
Item 12. Yes.
But item 12, there are two matters. The arising out of three matters, sir. In the matter, so there are three matters. The three matters, the content matter not very, it's not good. It's the only. Not very serious in policy.
But we will not get anything by punishing, we'll get orders and interim will protect us. They have all the time.
They are taken.
And my love, this matter.
This is the interim order that was operational during, before the honorable single judge.
Ready?
Yes.
They are not ready, at any time, my lord, they are not ready, my lord.
The whole difficulty is these are all elected.
It's a serious issue. Who is a father?
Who is
Malak's the
father.
learned
No, absolutely.
reduces
Audition.
and doesn't give us an opportunity of placing a
I
case.
have seen the first page that shows that
That is absolutely.
that son, whose son is the main.
Let me tell you, Lordship, what the issue about.
And who is the father?
And that kind of thing.
No, he is not. Let me tell you, Lordship, what's the issue. There are two matters, Miller.
Three province district.
This is Bhubaneswar.
Bhubaneswar.
District.
Bhubaneswar.
Yes.
Yes, ma'am.
And question of disqualification, there are, 1 second, there are two issues, Miller. One is the suspension 32(7).
He's saying that I have not read the brief.
That's a different matter.
The whole difficulty, interim order which was operating
Before
during
the
the
civil
pendency of
judge.
the writ application, and that order should be passed. But they cannot speak, if you not see the interim order passed by the honorable single judge, that itself, so far the judgment has been passed in the first case. In the first case, the order 32, section 32(7).
First case is disqualification. 28(3).
But the other case, suspension of management committee, that has not been considered at all, but that has been dismissed.
Dismissed, referring to the first dismissal.
You also look to that.
Absolutely, without any adjudication.
Now,
Two cases.
when this writ appeal was
Who is he?
fresh category, and
I
the
don't know.
order of status quo has been
Not
not
for whom he is appearing.
I'm for the we are supporting the state and
This is the problem.
It's a matter between register and we.
after
You have no-
almost 1 year they want a modification of
Sir,
no,
you don't have a right at all, sir.
You included as a party in a.
for the single judge we were also heard.
No, you are not. You have an application also.
No.
Before the single judge we were heard, we participated in the proceedings.
Can you, without your.
Even you are not filing application here also.
No.
Here we have our names are appearing, we have filed intervention.
No, you are not
That
given us
doesn't give you a right to address the honorable court.
The intervention application has been served.
No,
No.
Give a intervention application.
and that too, what right he has, sir? That is in between the state or the register and.
I just pointed out that there is a during fresh admission stage of interim order of status.
No, that's fine, he will be heard, but then your lordship may kindly hear us private
That is judgment of the case.
Kindly see that judgment, Lord. Kindly see judgment impugned here. That's a different matter, let him not confuse your lordship may kindly see the impugned judgment. Whether it stands scrutiny of law, kindly see, man. The kind of judgment, kindly see, man. Not the impugned judgment in my case.
Today, my lord, I'm just seeking accommodation, my lord. I will be prepared next day, my lord.
But one paragraph I am looking.
Let me tell what the issue.
Wants to place it, please.
Yes, ma'am. The issue is this appellant before your lordship, whether he get disqualified for begetting third child. That's the issue. Before the registrar has passed an order.
No. The issue is that
I'm coming, Lord. The register cooperative societies has passed an order disqualifying the elected chairman of the bank on the ground of having third child after the cutoff date.
Third child.
Yes, after the cutoff date. Lord, my only solitary point would be.
You say that you only have two child.
No, that's not the issue. I am not going to the facts. But I am on the pure question of law. It's a question of election dispute. Rule 57 says election of a elected person on whatever ground has to be called in question in the election tribunal. First. Second, register has no jurisdiction to pass the order of disqualification without the tribunal being heard in the matter. Now, what the Honorable Single Judge has done is, since the tribunal was not functioning, Honorable Single Judge, the impugned judgment para 9, has passed an order that I take over the jurisdiction of the tribunal and pass an order that you are disqualified.
Para 19.
Tribunal jurisdiction is a suit type jurisdiction. Parties have to lead evidence. Pleadings have to be there. Cross-examination is there. Full-fledged procedure is there for the tribunal. How can you take over the jurisdiction of the tribunal and pass the order?
So look to page.
Kindly see, Lord. Kindly see para 19 of the judgment.
You have three children or one?
No, in fact, I filed in my MA Those documents are tend to show that there are three disputes,
In fact,
adjudicated disputes.
where is the provision prohibiting that three children father cannot
Under the
participate?
There is a disqualification. 28 of cooperative society.
But that requires adjudication.
Adjudication.
Is there?
Yes, sir.
Yes,
In the statute.
In the statute.
Yes. They say that.
But that requires an adjudication. Pure disputed questions of fact.
You will adjudicate.
Tribunal, cooperative tribunal, KNC 67B.
Whether you have
Yes, third child or not.
But question of my third child.
you have brought the third child in the world or not.
The note.
Officer, have you seen the recent judgment of the apex court? The same ground.
But here is the difference.
We rejected the section 5 application. They went up. And what is the difference?
Only when I filed the contempt.
Everything we decided there and that was set aside by. Then what to do?
Here is the only case is what is in merit also. The authority who does not have the authority to dispense with my
He can
service.
enter into the merit provided we condone the delay because this is the hurdle.
It's 5 minutes even for your lordship. 5 minutes.
No, I understand, but we have to condone the delay. That's what I'm asking. Unless we condone the delay, we cannot enter into the merit.
Right.
Give him that judgment.
That judgment that I have gone through.
That is what.
That I have gone through. I have gone through and through that also I have some endeavor.
Domains.
Yes, to look at the court question. To the court question.
On the judgment of the Patra, where it said.
But here is a tendency of government developed to file writ appeal only to by the time, only to frustrate the.
Sir, I was parting many cases, around 250
Yes.
cases. Following Surama Mandiri, I all compact.
That is
So,
today's item 15.
to decide on that.
Today's item 15. Give it. That Damayanti Patra is also there.
Only for this I am conscious here.
No, read, sir. I will be requesting you to read. The delay was double the delay here. That was 421 days.
Learning council for the.
No, you sir.
In this case, my difference is in a given situation, the government is preferring in almost all cases writ appeal only to frustrate the.
What can be done, sir?
So it is because your lordship is.
You are. That is why we dismiss the section 5 there. We dismiss with the.
When invariably you will notice whenever we file a contempt, thereafter they will come.
It's the pan-India
Only-
scenario, sir. Pan-India, every.
Only to frustrate. On merit, hardly it will take 5 minutes.
Okay, this.
In after
Fraternity, fraternity is something.
Yes. Would you like to file objection?
to this, no.
Section 12.
Yeah.
This is an application for permission.
Only jurisdiction.
Premature retirement.
Only jurisdiction.
So SP has passed.
SP has passed the order of termination.
Who is the competent authority?
DG. And that is on the record. That is on the record.
The appointing authority, otherwise, I'll argue on that.
Item 14.
Come ready with the final one. But you also come ready with the final one on that day. Don't ask for it at the moment.
No.
That's the only issue. So
That is the only
relevant provisions of law.
Exam
Delegation of power.
Yes.
Delegation of power.
Yes. Whether that power is there.
Yes.
To delegate.
absolutely there is no power, no delegation.
Honorable Court have, the Honorable Single Judge have further held that to circumvent the disciplinary proceeding. The procedure under the compulsory retirement has been taken under the Odisha Service Code.
Let us see. That is the difference. We are not going. Only thing is.
Yes. No, not.
Yes, call the next.
Item 14.
This matter. This judgment taken this.
How many days delay, sir?
Delay, my lord, 165 days delay.
Have you served the copy?
Yes.
Who is appearing? You have received the copy?
My lord, I have received a copy, but my lord, they are private opposite party.
Private opposite.
So notice has to go to him. First week.
Item 15.
The content matter is there that to.
No, I understand. First week.
I appear for the appellant matters. Matters, I appear for the appellant in item number 15, matters.
Yes.
Yes, matters. This is right for arguments, matters. It has been remanded back by the Honorable Supreme Court, matters.
That case that my lord was just now referring to that.
Yes. Argue on merit.
Matters, I'm being recent. Yesterday night, I was, my lords, told to argue the matter, matters. I'm requesting some time.
Sir, you have gone there. Court has said that we should hear out the matter immediately.
Understood, Malas. Unfortunately, what has happened, the earlier council has withdrawn the file yesterday evening. That's why I was engaged again. So I'm requesting some time to go to the file, Malas, and argue on the next date, very next date, whenever my lord says. I'll argue on the next date for sure.
Despite the matter being listed for
Item number 16.
Ignored your lordship. My appeal is
He has said
My
that you got for.
my lord. Great.
Item 16.
Look, the vacation of state petition has not been served. Copy of the vacation of state petition has not been served.
You wanted a vacation of the interim order?
Vacation as well as happening. My lord, we have a very small prayer. My lord, there are 3 people and 3 blocks.
What is the interim order? You wanted a vacation?
The stay order has been passed
Of the
honorable single judge, as well as an appropriate on order for appropriate. My lord, basically the appellant has challenged the single judge order in WPC number 5258 of 2025. I was the petitioner there.
No, where is the interim order?
That is on dated my lord 6/5/2025.
I'm looking at that order. Where is the interim order?
By the IN number 2296.
Huh? WN number?
WN number 809 of 2025.
Yes.
The lordship has passed the order.
Yes.
In
This
IN
is
number
the interim order
2296.
shall not be given effect to till the next day. What is the ultimate decision in the or interim order? What is the interim judgment?
Judgment is under the
Annex 1.
My lord, without giving an opportunity of being had, and without issuing notice in the writ petition, my transfer order has been passed and I was reverted back to my original place, previous place of appointment. The lordship has clarified in your lordship's order by the lordship. Paragraph 6 of the order. Let me classify paragraph 6 of order. The appellant who was arraigned as a party in the said writ petition was not served with a notice, and the said writ petition came to be disposed of in his absence. The tenant of the direction passed in the said writ petition, as reproduced herein above, raises a legal point whether court can interfere with the order of transfer issued by the authority, and the mannerism in which the direction is passed has inculcated the sense of usurpation of the power exercised by the administrative authority under the fiat of Article 226 of the Constitution there, we thus find.
Yes, but tell us that what is the law?
My lord, as per the recent instructions received from my client, we have no objection to the writ appeal. Our only prayer is for appropriate posting, that is IN number 2947. May I place the fact?
Appropriate posting, when it means the posting where you were there.
No, my lord. May I place some?
Where you have been transferred, you go there to that posting.
My lord, 3 people were involved and 3 blocks were there. The present appellant, respondent number 6, that is me, respondent number 7. 3 blocks, Hinjalakat, Barapalli and Bhatli. By the transfer order, appellant transferred from Hinjalakat to Barapalli. I was transferred from Barapalli to Bhatli, and respondent number 7 from Bhatli to some other. Respondent number 7 agreed by that order, filed a writ, notice was issued, interim stay was granted. By that time, all of us has joined a new posting. Because of that interim order, he stayed at Bhatli. I was told to go back. My acceptance was declared non-accepted. I could not join my previous place because the present appellant was there. I had to file a writ. Again, by common order, all 3 were reverted back to their original position. Now, the present appellant, being agreed by the single judge order, filed this writ appeal. Another time, this stay order was passed by this bench, by virtue of which he stayed at Barapalli. The respondent number stayed at Bhatli. I am hanging in between, my lord. I have no posting since the last 10 months, my lord. I have been staying unemployed.
What's your name? I mean the name of the client.
Saroj Kumar Mahapatra, my lord.
Saroj Kumar.
Respondent
Who
number
is
6.
this Arpan Kumar Pujari?
I am the appellant. I was transferred. I am the appellant.
Arpan was
Your matter does not come.
My lord.
You are a party here.
Yes, my lord. Respondent number 6 in the present writ appeal.
Yes.
The current situation, we are not. We are not objecting to
state.
this posting. We are only asking that we may be posted
The
at
very innocuous prayer. We will allow.
because only 3 months.
Very innocuous prayer, he says that I have no grievance, you put me anywhere,
Exactly, madam.
but you cannot keep me in vacuum. Because it was a chain transfer actually.
Yes.
Once the one transfer is a state means the entire chain is
have to
disrupted.
break.
What has happened that somebody, he has gone, he has joined the another post where he was there.
Yeah.
And he was not permitted because there is a stay in that post.
Exactly.
And the old gentleman is still occupying. Now he cannot.
That person
So
was
why don't you revert him to his post, the other post? He has gone to his post.
But that third person has been posted at Gaisilat block.
He did
He
not
did not
join
go.
there. He directly filed a writ petition and,
And it is within the that work permit to
20 days gap.
Bhartli, it is only 10 kilometers burger.
I do not want to go in. I find the stand of this litigant
Gaisilat minor block.
is absolutely genuine.
Yes, fine.
That because of this, I cannot be kept in limbo.
Exactly. That is my only
I
3
see
months
that
are left for my retirement.
Wherever you want, he is agreeable. You put him anywhere, but
Exactly.
he wanted to be posted.
In last 10 months, they have not given me salary, no posting, nothing. I'm sitting unemployed at home without any fault in this whole procedure, madam.
This is unexpected and this cannot be done. This cannot be done.
Only 3 months are left for my retirement and they are not giving me posting. My service will not be declared.
You talk to the officer. You talk to the officer. If you cannot place him to his original position, then place him to any other position.
Exactly. Yes, my lord. We are not objecting. We are only asking for any vacant position.
Anywhere in the state, wherever you want, post him.
Next week,
You take steps immediately. We are keeping this matter on Friday. This first matter on Friday. No issue. This is absolutely let's say genuine demand a employee has to raise.
We are concerned about respondent number 6 there.
Yes. Instead, order may continue. Item 15 and continue my change. My previous post has been filled out in Jutland. I cannot go back there. That is 350 kilometers.
You go anywhere. We will also say, find out where he can also be posted.
Well, may I mention, my lord? Well, may I mention?
It is there.
Item 17.
Weekly said 10 kilometers. Okay.
I have come from 350 kilometers. They have been transferred to 10 kilometers. Bhartli and Gaisilat, 10 kilometers within this.
That area.
Yes, item 5 on the weekly list. Virtually my business has shut down. So, listing without notice. Your lordship has said we will give you this.
You have seen this.
Doesn't I?
Documents are in that way.
Doesn't I hear that?
All interim are being continued. And before the vacation.
May I mention your lordship with
CAV with me, I think my brother has at least equal. 4.
That's a
So I have to dictate, otherwise I am not going to hear out.
That's a fair, all interim orders.
Yes, interim orders to continue if there is any.
Yes.